part of these proceedings, there is a response by the Attorney General under Section 36 of the Criminal Justice Act 1988 and the Section 45A of the Youth Justice and Criminal Evidence Act 1999 applies.
Thank you very much indeed. Yes, Mr. Little.
Please, my lady and my lords.
Before we go any further, can we just confirm the order under Section 45A of the Youth Justice and Criminal Evidence Act 1999 is in place? A number of witnesses were under 18. And there are restrictions imposed under that section in respect of a victim or witness for life. I'm not going to read out the full terms of the order, but I hope that the names are well understood. And if anybody needs a full copy of the order at this stage, please could they say so. Yes, Mr. Little.
Thank you, my lady and my lords. As you know, I appear on behalf of His Majesty's Solicitor General on this reference in respect of the offender, Urfan Sharif. I also appear for the respondent, along with Mr. Lloyd, who was junior counsel at trial, although I was not trial counsel, although I was originally going to be trial counsel in relation to the applications for permission to appeal. The applicants are represented by Mr. Urfan Sharif by Mr. Mian, King's Counsel, who's immediately to my left, with his junior, Mr. Bassin, Beinash Batool by Ms. Carberry, King's Counsel, and I believe that her junior is attending via CVP.
Yes.
Mr. McGarvey, and Faisal Malik by Mr. Ivers, King's Counsel, furthest away from me, and the junior counsel, Mr. Taylor.
Yes, indeed.
Subject to any contrary indication from the court, I was intending to make my submissions in relation to the reference first, then let my learned friend respond as well as make his application, then let my learned friends make their applications, and to the extent it's necessary.
Well, in all candour, we had wondered whether we should hear from Mr. Mian and the other applicants first on a rolled-up basis for you, Mr. Mian. That is to say, also responding, as it were, to the reference. But if you've had a discussion and, Mr. Little, you are ready to go, we have no strong views on the subject. Has there been a discussion at the bar?
There's been limited discussion, milady.
I don't feel strongly about it, but Mr.
Personally,
Mian.
I'm neutral.
All right, well, in that case, Mr. Little, off you go.
All right, thank you. The facts are set out in the usual way in the final reference,
yes,
in some detail, and of course the sentencing remarks are very detailed in relation to the facts. My submissions are also set out in some detail in the final reference.
Yes.
And that document also addresses the well-established applicable principles. Those principles, I submit, are well-known and well-established, and while sometimes slightly different language has been used, the reality is that although this ground is regularly traversed by special court constitutions, it's well set out in Stewart and others at paragraph 19. Before turning to those principles,
For our part, I think the paragraphs we found most helpful are paragraphs 19 and 81.
Yes, quite. Before turning to those principles, though, which I'll only do briefly, can I just make this clear, and I hope realistically? I acknowledge that the judge was very well placed to make each one of his factual determinations. He presided over a very lengthy trial. He made a number of important findings of fact as to what had happened, all of which we rely upon. I also acknowledge that the sentencing remarks are comprehensive, well-structured, and plainly, carefully considered. The only error that we submit that was made is the ultimate decision in relation to the first offender. Turning then, if I may, to the relevant principles, which I hope can be distilled as far as this reference is concerned shortly. First, Schedule 21 sets out a detailed framework, but it is not and has never can be exhaustive. The assessment of seriousness is always case-specific, and it must not be applied as a straitjacket, and for reference, really, that's paragraph 19, Roman 6 of Stewart, but it's well established in the other authorities. Second, all cases of murder are serious, some more serious than others. Stewart 19, Roman 8. And third, it is only in a rare situation that a type of case not listed in Schedule 21, paragraph 2, will merit a whole life order. It will and can only do so when it is properly understood to be a case of exceptionally high seriousness in the context of murder cases, and only when just punishment requires it. Again, 19.4. Fourth, it's a remedy of last resort for a very limited number of cases of the most extreme gravity. Again, really, 19 Roman 4. And my submissions, I hope, acknowledge and take into account those 4 principles. The question is, was this one of those cases or not? If it was, then the judge was wrong, and if it wasn't, then he was plainly right.
Do you accept as a matter of principle that the manner in which the case is put below by the prosecution may be relevant to the question of undue leniency?
Yes, of course. That's obviously the second authority of Stewart as well, although the prosecution didn't take whole life off the table, if I can use that vernacular. And so I submit I'm not really even in Stewart territory as far as that's concerned. This was not a self-denying statement by the Crown, which does occur, which isn't a bar to a reference, but plainly, when highly experienced counsel and a trial judge that sat through a trial have come to a particular conclusion, I accept that the threshold or the incline that I have to address is a high one and a steep one.
I mean, just for the benefit of everybody in court, so we're not talking in code, is it fair to say that whilst the option of a whole life order was one, to use the words of leading counsel, that merited at least serious consideration by the judge, the gravamen of the submission was that this was really particularly high, not exceptionally high offending?
Yes, I accept that. Of course, I'm stating this as a general proposition rather than giving evidence. Of course, until one sees what the judge's ultimate assessment of the facts were, which can sometimes be more serious or conclusions more serious than prosecution counsel are concerned. For example, it can sometimes be conceded that there wasn't an intention to kill, and a judge concludes to the contrary, as in the case of Tustin, in fact, as part of Stewart. But I don't disagree with the general point that Milady's made.
Understood.
To me. This was not a case in which the Crown was saying, although they're perhaps they're even rarer than the rare cases meriting a whole life order, where the Crown say that the only appropriate sentence is a whole life order. They arise perhaps not in all of the whole life order cases, but I accept that this was not a case where the Crown was saying we submit it's a whole life order or alternatively particularly high seriousness.
You're entitled to say, I think, fairly, the prosecution is making its submissions without knowing what precise findings the judge is going to make for the purposes of sentencing.
Quite. I don't think really that I can develop that any more than the way that Milady's just distilled that. And that has some importance or relevance, or perhaps it's really the only ground upon which we make this application is the conclusion of conduct which the judge, who had carefully considered whether to use this noun or not, concluded that this was torture. And it really boils down to this to a certain extent, that it is the extent and the duration of that conduct, not days or weeks or months, but years, which we say, when one stands back and looks at really the way that the judge started his sentencing remarks, and I accept that, of course, it's not the test of whether a case merits a whole life order in the way in which he articulates himself about the courts at the Old Bailey and few cases such as this, because, of course, there are many serious cases tried at the Old Bailey that don't get close to a whole life order. But the findings of fact were significant in this case. And it's not that we are quarrelling with any of them, quite the converse. We submit that it is on those particular facts that the judge did not then go on, we submit, to consider properly the question as to whether to impose a whole life order. Now, I accept he made it clear that he had addressed his mind to it. He was obviously referred to Stewart. All of those points, as it were, can be taken against me. But as the court knows, he simply stated your offending does not come within the class of offending for which a whole life order would be appropriate. I suspect it may be said, well, if the Crown had put their case more fully or strongly in relation to whole life order, perhaps he might have said a little bit more. But it's not clear what he meant by that. Did he mean it doesn't fall within para 2 and therefore I'm not going to impose it, or did, as it may be said against me, could be inferred, he'd been referred to Stewart, he knew what the position was. Is that just a shorthand of saying I've considered it properly? That's, we submit that a judge here, when the Crown were not withdrawing it entirely, and given his findings of fact, he could and should have said more. He wouldn't need to have said much more, but he doesn't in our submission make clear whether he's considered on his own findings of fact whether this is one of those rare cases in which a whole life order should be imposed, despite the fact that the case does not fit in to paragraph 2.2 of Schedule 21.
It's difficult to submit that he didn't understand that it was a non-exhaustive list.
I'm not going that far.
No.
But can I really just distill the submission then in this way? It's of course accepted that this conduct did not fall within any of the categories of case that fall within paragraph 2.2, but they are not exhaustive, and this was, we submit, a truly awful case of a murder of a child. It is invidious to enter into comparative exercises about that for obvious reasons, but there must, we submit, come a point at which the balance can and does tilt in favour of the possibility, if not the reality, that a whole life order should be imposed in such a case. And it is not self-evidently limited to a single murder of a child that is premeditated and or planned. The issue here was, in our submission, the judge correctly considered that, as it were, it was not appropriate to start with a starting point of 15 years. One can move from a starting point of 30 to a whole life order case. They are rare, and I acknowledge and accept that the one notable example of when that has happened involved a case that fitted squarely into paragraph 3.2 to start with, in other words, Wayne Couzens, before the panoply of aggravating features elsewhere merited properly a whole life order. But we submit that nor is it the position that it could never be the situation in which one doesn't automatically fit into paragraph 3.2, nor in 2.2, but one could properly impose a whole life order. And in short, we say that when one considers the duration, extent, and nature of the offending here, this case does cross that very high threshold of being such a rare case in which a whole life order would be appropriate. And indeed, I have to submit the only appropriate sentence, because that's, in essence, the threshold I need to cross.
That is the threshold.
Quite.
Anything less, simply not acceptable, you
no,
say. You have to say.
I entirely acknowledge that, and I also acknowledge that there could well be a category or species of case in which one judge could impose a whole life order and another judge could impose a very, very lengthy minimum term. That it would be absurd to suggest that you could not have such a situation given the nature of a sentencing exercise. So, as I said, it's a high hurdle and it's a steep incline for me to cross. But standing back and considering the underlying facts here, they are in our submission such as to properly justify and merit categorization as an exceptionally high serious case of murder, and sufficient so that the only appropriate sentence on the findings of fact was a whole life order. But unless I can assist the court any further, I don't think I help the court by, as it were, repackaging the submissions that I've already made orally and that we've set out in writing.
You've been very clear. So those are your submissions on the Solicitor General's reference on Sharif. So, Mr. Meehan, you will deal both with your application and the response, and then, Mr. Little, if you have anything to say in response to the applications.
Yes.
Your turn will come at the end of everybody's submissions. Thank you.
Thank you, my lady, my lords. My lady, dealing first of all with the Solicitor General's application,
Yes.
we say, without hesitation, that this is not one of those exceptional cases, and therefore the threshold into a whole life tariff is not crossed. The principles are set out in Stewart. The court will, of course, be more than familiar with each of those principles set out by Lord Burnett in his judgment in the case of Stewart and others. And we say that his lordship, at first instance, having been seized of a trial which lasted a number of weeks, having heard all of the evidence, having heard Mr. Sharif give evidence, and the volte-face that came during his evidence, concluded at paragraph 54 of his sentencing remarks, addressing specifically Mr. Sharif, your offending does not come within the class of offending for which a whole life order would be appropriate. Now, of course, his lordship was referred to Stewart, and of course his lordship was referred to the case of Tustin, which was also dealt with at the same time as Stewart. More of that in due course. But the suggestion that somehow that is an ambiguous statement in some way, or ill-informed in some way, in our submission cannot be sustained. That's so far as the unduly lenient sentence
All right,
is
well
concerned.
then I'd just like to explore one aspect
Please.
that you haven't mentioned, and that is the judge's finding that there was a lack of intention to kill.
Yes.
Now, it's said against you that that was only scant mitigation when it comes to looking at minimum term, but does it carry weight in the context of consideration of a whole life order? Is there a different contextual or qualitative aspect to consideration of this issue in the different contexts? So is it relevant to whole life order in a way that it might not carry weight in terms of pure mitigation on the murder counts in this particular case?
Milady, I have in mind the observations made in the case of Peters, and that observation in particular is that actually in some instances a lack of premeditation is neither here nor there. A lack of an intent to kill is neither here nor there. But in this particular case, it was advanced on the basis that there was no intention to kill, and that was accepted by the sentencing tribunal. It was advanced by the prosecution. This was not premeditated, and that again was accepted
Well,
by
the death was not premeditated.
Precisely, yes. And so, turning those principles or those observations by his lordship to the question that my lady has posed, we would say that there must be an intention to kill, there must be substantial premeditation in order to assist the application from the Solicitor General to overcome the high hurdle that all parties recognise must be overcome.
I'm not sure that it's as absolute as that, but I'm really just asking whether it's a factor you rely upon in response to the reference.
Milady, yes.
Thank you.
And turning briefly, if I may, to the proposition that this was exceptional. We can all agree, my lady, that this was a tragic case. We can all agree that what Sara was subjected to was horrendous. Regrettably, it is the case that cases of this nature are not unique.
Well, how does that help you?
We don't say that it necessarily does, but it contextualizes this case insofar as any suggestion being made that it's somehow exceptional. And one has in mind there the case, well, there are any number of cases, but in particular, the case referred to in Stewart, that of Tustin.
But I thought you had moved on from the reference now, and you are now addressing your application
Forgive me,
for
I had.
leave.
That's just
Right.
one final observation
Fine,
so
thank
far
you. I
as
have it. All
the
right.
reference is concerned.
Thank you.
Does Milady have any questions so far as the reference is
No,
concerned?
thank you.
Thank you. Moving on for the application for leave to appeal against the sentence, on which we say the minimum term of 40 years, which was, of course, reduced under the slip rule to 38 years and, forgive me, a number of days. That was...
It's all right, we have the days.
Thank you. We say, lady, that that sentence is plainly manifestly excessive. And we say that because what we recognised at the sentencing hearing was that there would be a significant uplift. Our contention was the starting point was 15 years.
You accept today that 30 years was the right starting point?
Milady, we accepted at the sentencing hearing that the notional starting point, and we put it in those terms, the notional starting point, because it didn't fit comfortably, the facts didn't fit comfortably into any of the preceding paragraphs. So the notional starting point was one of 15 years, which we accepted would be subject to a significant uplift. Now, that significant uplift in our submission was made by virtue of the fact that, as paragraph 7 makes clear, there must be consideration of the aggravating features. And so the significant uplift must, in our submission, have been informed by at least some of those aggravating features. An uplift of 15, from 15 to 30. Now, of course, His Lordship rejected the submission, or our contention, that the starting point was 15 years, but that was a notional starting point from our stance because it didn't fit, the facts of the case did not fit comfortably in any of the preceding paragraphs. And so we accept that the starting point is 30 years, particularly high. But that...
Sorry, it's my fault, I'm confused. You say it's a notional starting point of 15, but you accept a notional starting point of 30.
No. The notional starting point is 15 because it doesn't fit comfortably within the preceding paragraphs. But it is just that. It's a notional starting point.
So you accept a term of 30. Is it
Yes.
a starting point of 50, but you accept a term of 30 for aggravating features?
Precisely.
Right, thank you.
And so the
As I understand it, you accept the judge was entitled to take his starting point as 30 years.
Absolutely. Yeah. Our contention is that that starting point of 30 years was informed by the aggravating features.
With respect, that's misunderstanding what starting point is.
Exactly.
Starting point is a creature of statute.
Mm-hmm.
So if it falls within the category, it's 15, it's 25, it's 30, and so on. And so I think your submission is that this, because you say it didn't fit in easily within paragraph 3, and therefore you argue it should have been a starting point of 15, but a sentence of 30 after aggravating factors. It's not a second starting point. But can I just then ask you this? Is the test really just whether the case fits comfortably within the examples, ignoring the fact that the case was obviously exceptionally serious or of very high seriousness, therefore naturally to fall within paragraph 3?
Well, our position was and remains, my lord, that because it didn't fit comfortably into the preceding paragraphs, His Lordship's conclusion that it must be a 30-year starting point, which we accept, was informed, as paragraph 7 of the schedule makes clear, by some of the aggravating features. And so it then says in paragraph 7 that any other aggravating features are then taken into account insofar as they haven't been taken into account to reach the starting point. And so our submission is that, yes, we accept that given the nature of the case, any starting point, 15, would be subject to a substantial uplift. We accepted that, and that's what brought it from the notional, if I can put it that way, or from the starting point of 15 up to 30. The question then becomes, my lord, well, having considered those aggravating features which have resulted in such a substantial uplift, what are the additional aggravating features that then take it to the 40-year threshold? And that's really the nub of it. We accept that there had to be a substantial uplift.
But now, beyond 30 or just up to 30?
Beyond 30.
Right.
Beyond 30.
So some aggravating features take you from 15 to 30, take you from a starting point of 15 years to a term of 30, and you accept that in addition there were some extra aggravating features to load onto the 30, but not up to 40.
Yes.
Right.
And, so, and it's stated in terms, in some respects, we say that the considerations that his lordship had in mind are encompassed in the additional aggravating features that his lordship then went on to identify. And that, we say, is in paragraph 54 of his lordship's sentencing remarks, where his lordship makes the following observation. The way that you treated Sara, culminating in her murder, means that your conduct was of such seriousness as to warrant a 30-year starting point. That's paragraph 54, my lord, of his lordship's sentencing remarks. The way that you treated Sara, culminating in her murder, means that your conduct was of such seriousness as to warrant a 30-year starting point. Now, in our submission, that course of conduct must encompass many of those later aggravating features which his lordship identifies as pushing it from the 30-year starting point up to 40. And so, in effect, what we are saying is that his lordship, despite saying in terms that he was not double counting, did in actual fact double count. And that is perhaps illustrated if one turns to paragraph 59 of his lordship's summing up. Paragraph 59. I have borne in mind that some of the aggravating features in this case also contributed to the conclusion that the 30-year starting point was appropriate, and so I have been careful to avoid double counting. This applies in particular to the mental and physical suffering that was caused before Sara's death. And here's the nub of this particular submission. Nonetheless, the degree of mental and physical suffering that you caused to Sara was, in my view, so extreme as to amount to an aggravating factor in this case, and taken together with the other aggravating factors means that a sentence of 30 years would not reflect the gravity of your offending. And so our submission, so far as that is concerned, is that, well, his lordship's clearly identified a course of conduct, and that course of conduct is the suffering, mental and physical, that Sara was put through. But nevertheless, having used that in order to get to the 30-year starting point, there is in effect an additional consideration of that particular aspect as an aggravating feature when it's already been taken into account to get to the 30-year starting point. And so the question then becomes, well, if that's right, well, how has it been apportioned? When does it become something that can then be taken into an additional factor, aggravating factor, when it's already been taken into account? And many of those other aggravating features that his lordship identified, and they begin so far as Mr. Sharif is concerned from, forgive me, my lady.
Right, 56 and 57.
Thank you very much. From 56 and 57, and then follow through. Before that, 56 and 57, I have no doubt, and Milady, of course, has the point. I don't intend to rehearse them, but there are a number of aggravating features there, which in our submission must be incorporated into the course of conduct that his lordship identified at the very beginning in order to get it to the 30-year starting point. And if that is right, if, for example, the course of conduct includes using restraints, mainly consisting of packing tape and hoods made out of plastic bags, that's point number 6, my lady. Use of weapons, that's point number 5, my lady. No doubt that Sara was singled out for harsh treatment, that's number 4. In our submission, each and every one of those particular aggravating features, which are identified as being non-statutory aggravating features, must in our submission be part and parcel of the course of conduct.
That may be so, but if there are so many aggravating factors here, and some of them, albeit dealt with briefly, if you break down into the number of incidents, the duration, the circumstances in which these, for example, restraints were used, is it not legitimate to say, well, of course it's part of the overall picture that takes us to particularly high level of offending, but there is so much more. There is so much more in this in terms of the extent and nature of the offending that you can take the same factors as a matter of identification as reasons for using them, as it were, the weight of them again to go over. And that's sort of what the judge has done, and it's not a mathematical exercise.
No.
Identifying percentages or figures on it. It's just saying a just and proportionate sentence here with a point of 30. There is so much in here, so much terrible, terrible offending, as you fairly recognise.
Yes.
That's how the judge saw it. What's wrong with that?
Well, my lady, it is of course right that it's terrible offending.
It's not just one restraint, it's not just one weapon. It's not, there's so much to it. So you have to reflect the full weight, don't you?
Absolutely.
The full weight of all of this activity.
Absolutely, and we fully accept that, as we did at first instance. Mm-hmm. But the reality of it is this, and one, of course, accepts that putting cases next to one another isn't necessarily helpful. But of course, what can't be ignored is the case of Tustin. In that case, as in this case, his lordship concluded, well, it's the preceding history of violence that is aggravating. It is also a series of subsequent incidents that aggravate, physical violence and so on, videotaping, salt poisoning.
Well, do you want us to, I mean, I hadn't appreciated, no doubt my fault, that there was any particular emphasis being placed on Tustin. Would you like to just take me to the relevant bit that you say would assist us?
Yes.
Please. So we're in Stewart, and we need to look at paragraph...
So far as Tustin is concerned, lady, it is...
Para 174, the discussion on Tustin starts.
Yes. (168).
Thank you very much.
168, my lady, in considering the circumstances of the attack...
168 is Stewart, yes.
Yes. case. That's page 135 of the bundle prepared by the Crown.
Thank you very much.
In considering the circumstances of the attack which caused Arthur's death, the judge concluded that when Tustin launched the attack, she intended to kill him. The judge reached that conclusion taking account of the amount of force used and because she no longer wanted Arthur in her home. She wanted Hughes to provide for her and her children untroubled by the presence of Arthur. She also failed to get any help for Arthur immediately after the attack. Now, that resonates in the instant case because it was an aggravating feature that Mr. Sharif and indeed his wife failed to get any medical assistance.
I'm looking for a point of principle, Mr. Meehan. What is the point of principle from Tustin that will assist us?
So far as that's concerned, it's perhaps better to turn to paragraph 175.
Thank you.
And this, of course, is headed discussion.
Yes. The judge was right in his observation that only one of the factors identified in 3.2 might have taken the murder into particularly high serious category. So we can read these paragraphs. What is the point that you take from Tustin for us? That
The point that we make, milady, is that despite all of the history, the preceding incidents of violence which are present in the incident case and in Tustin, the starting point of 30 was arrived at, as is clear with our case as well, but having considered aggravating and mitigating features thereafter, the final sentence was one of 29 years. And this is a case in which there was a history of violence. And in our submission, at paragraph 1, and that's echoed in paragraph 175 of the sentencing remarks of His Lordship the Judge at first instance. Paragraph 175, it was the antecedent, protracted and serious cruelty which did have an element of sadism that, on the judge's reasoning, firmly placed this case at a minimum starting point of 30 years. And that's paragraph 175, my lady.
Right, well, we will have a look at Tustin, but those are the paragraphs you'd like us to consider.
Yes.
Right.
And so, putting it, I hope, as concisely as I can, but what we say is that there can be little argument that this was a case which warranted a 30-year starting point. In reaching the 30-year starting point, His Lordship the Judge, quite rightly, took into account the preceding history of violence and took into account the statutory aggravating features, the abuse of trust and so on. The subsequent aggravating features, in and of themselves, our primary submission is that they are encompassed within the course of conduct highlighted and identified by His Lordship the Judge.
How can that be right when we've got the fleeing, the disposal of evidence and all the rest of it?
The fleeing...
Yes? How is that part of
and this is actually...
How is that part of the course of conduct preceding death?
The fleeing, the course of conduct, and destruction of evidence. Those we, of course, recognise are aggravating features, but what we say is that they do not warrant an additional 10 years.
So are you saying that anything before death is included in the 30 years and anything afterwards doesn't warrant going up to 40?
Precisely.
You're actually drawing a temporal line like that, are you? Right.
That's the essence of our submission, my lady.
All right, that's helpful, thank you.
Can I be of any further assistance?
No? Anything? No. Thank you very much, Mr. Meehan. Mr. Buzzin, do you wish to follow? Thank you. No, thank you. Ms. Carberry.
lady, my lords, may I make 4 short points by way of introduction so you know where I am coming from, and then 2 principal submissions. 4 short points. Nothing we say today on behalf of Beinash Batool detracts from the horror of Sara's treatment by those who were trusted to care for her, and from Beinash Batool's role in her murder. We recognise the difficult task the sentencing judge had to undertake in this case. We agree that he was immersed in all the evidence and was therefore uniquely placed to make the findings of fact he did, and we accept that it cannot reasonably be argued that the judge was wrong to find this offending overall to be particularly high in terms of seriousness to support a starting point of 30 years. And I say that taking into account the period of time over which Urfan Sharif meted out violence on Sara, the cruel nature of the punishments he inflicted over a long period of time, and Sara's suffering in those terrible final weeks. Moving on from those 4 points then, my lady, if I may, to the 2 principal submissions we make in support of our application that the sentence of 33 years was not a just and proportionate sentence in her particular case. First, Beinash Batool's culpability is significantly lower than her husband's. And although the sentencing judge quite properly recognised her secondary role, he did not, we respectfully submit, give sufficient weight to it. 2, although the judge recognised what he properly referred to as, and I quote, significant mitigating features in her case, unlike the position of Urfan Sharif, we say respectfully that insufficient regard was given to those, so that the right balance between aggravating and mitigating features was not achieved. My lady, may I turn then briefly to the first of those submissions. I'll call it the culpability point.
So in your helpful written submissions, you opened with double counting. Is your focus, in fact, on level of culpability and inadequate regard to mitigation?
Yes. These features are all intertwined, I suggest, my lady.
Well, double counting wouldn't be.
Well, it may be intertwined when one assesses the aggravating and mitigating features. So I will, with your leave, deal with that.
All right.
In the second part of my submissions. Returning, if I may, to the role, the culpability issue. There was no dispute at trial, my lady, that Beinash Batool was a secondary party, and there was no dispute that her participation in assaults on Sara came close to the end of Sara's life. Indeed, the judge identified at paragraph 16 the following features of her involvement.
Yes.
Beinash Batool did not stand in Urfan Sharif's way. She did nothing to protect Sara. And he said to her, "You encouraged and assisted Urfan Sharif in his assaults, although I cannot be sure that until near the end you actively participated in the assaults upon Sara." And the judge further recognised at paragraph 63 the following: it is clear that you were sincere when you expressed your horror and concern in the early stages about the way Urfan Sharif treated Sara, but you did next to nothing about it, and you became used to it and complicit in it. Those are the circumstances, my lady, of how she became involved, and that is in stark contrast, we suggest, to Urfan Sharif's involvement in the terrible treatment of Sara over a very long period of time as instigator, long-time inflictor of violence and cruelty. His controlling and manipulative character laid bare after 6 days in the witness box, blaming his wife.
My Lord has a
I
question.
can see you.
Weren't there times when she went beyond that, apart from joining in later on, where she was an enabler?
Yes.
So seeing that Sara was upset and having difficulties, knowing what Sharif was going to do, called him home to deal with her.
My Lord is quite right, but that was in the final weeks of Sara's life.
I'm not sure that's right. The calling home, is that right? When did that first start then? I thought that that was an early feature.
We had, in this case, at trial, telephone evidence in a large schedule, which only went back a matter of weeks or months. The date
Right.
escapes me.
Because
right
it had
now.
been disposed of.
No, it's still very much available, and we can.
No, but
certainly-
why did the records not go back beyond that?
It was the choice of the
Right, I see.
Crown to rely
Okay.
on the call data for that limited period only.
Thank you.
And it was that period of time in the weeks and short months leading up to Sara's death where the judge, and we accept, was entitled to find as a fact regular calls during the day, which may have been this appellant calling the defendant.
When you say the short months, most of the evidence of her injuries were within the last 2 months.
They were.
Fractures, the burns, the restraint during that period of a few months.
Yes, the medical evidence of the injuries related to injuries that had been inflicted in the 6 or so weeks, my Lord is quite right, leading up to Sara's death. The evidence of Urfan Sharif's cruel treatment by way of assault and punishment of her came from messages from Batul to her sisters outlining other incidents where Sara had been cruelly punished and injured. So far as her involvement is concerned, as I said right at the outset, I do not seek to detract from the horror of her treatment or from Beinash Batool's involvement in it. I simply seek to distinguish her involvement from that of the instigator and long-time inflictor of violence and cruelty. And indeed, the sentencing judge found that distinction too. So I won't shirk, of course, from her part, but her part came in those final weeks or so after a long-standing campaign by her husband. My lady, I recognise, of course, as I must, that the provisions of Schedule 21 apply equally to secondary parties. However, in her case, a straightforward application of the framework in Schedule 21 has I respectfully submit, contributed to a severe end result, which does not appropriately reflect her reduced culpability. And I recognise, of course, as I must, that it is sometimes inapt to compare and contrast sentences, invidious, in fact, as my learned friend for the respondent said. No two cases can ever be the same. However, my lady, we do suggest in her case, this court may be assisted.
Well, give us your best case that you think will assist us outside the principles identified in Stewart.
Well, I rely on the case of Stewart.
Yes.
And the appeal of Emma Tustin. I don't suggest for a moment that it lays down any new principles or guidelines, but we invite the court nonetheless to have regard to it, and in particular to have regard to paragraph 177.
What does that tell us?
It's simply an observation on the facts that in the Tustin case, the unspeakable violence and cruelty against Arthur was at the top end of the scale, taking the quote directly from the judgment.
And so how does that...
I don't suggest that this...
And what's he relying on the result in Tustin saying?
I'm so sorry, my lady.
Sorry, so what do we take from that? So Tustin involved unspeakable violence at the top end of the scale, and so...
which warranted a starting point, clearly, of 30 years. And I also invite the court to consider a paragraph that has been pointed out by Mr. Meehan, 168, that in coming to that conclusion, many aggravating features had already been considered in support of that starting point. I don't, of course, necessarily align Beinash Batool with Emma Tustin, for Emma Tustin was the inflictor of extreme violence, which led to Arthur's death and to the substantial cruelty that preceded it. But her sentence, after a starting point of 30 years was found to be appropriate, was a sentence of 29 years, and the court deemed that to be appropriate. And I simply draw the distinction, my lady, if I may, by referencing the Tustin case, that its distinction can properly be drawn between Beinash Batool's culpability and that of a primary offender.
Well, I think that's common ground.
My lady, then, moving on, if I may.
Just pausing there, on
I'm so
primary
sorry.
offender, your client was also a primary offender towards the later stages. Jointly participating in assault.
Yes, she certainly was
You
jointly.
said secondary,
she was a joint...
and I understand that, but it went beyond being a secondary party, even if a distinction is to be drawn on that basis.
She was jointly charged, jointly convicted of a serious offence. Her role in that offending was different. She had, the sentencing judge acknowledged in his sentencing remarks, a different role to play.
Yes, the point I was just putting was that she participated actively in assaults, and they're set out at paragraph 62 in particular of the sentence.
Yes, she did, and again, I don't resolve from that.
Yeah.
The only, if I may, active participation that the court could find as a fact in her case was limited to two examples.
What, the bites?
Yes.
On the arm and the iron?
Yes,
Tying up.
bites on the arm and leg,
Tying up and hooding.
And the iron. So terrible.
And the tying up and hooding.
Yes, you're quite right. Terrible acts of cruelty and violence, and of course I accept that on her behalf. But the injuries which caused the multiple broken bones about her body were not inflicted by Ms. Batul. My lady, may I move on then to the second part of my submissions? The aggravating and mitigating features, and within this submission, the element of double counting, if indeed it can properly be called that. We recognise that an assessment of aggravating and mitigating features is not a mathematical calculation, but here the judge, although he did not spell out the calculation, significantly increased that sentence from 30 to reach a minimum term of 30 years. And in doing so...
Sorry, 33.
33. Yeah. In doing so, we respectfully submit that he gave too much weight to the aggravating features and too little weight to the mitigating features. We invite the court to consider that the 30-year starting point is already elevated because it is reserved for cases of particularly high seriousness. It must, as this court recognised in Tustin, take account of the many aggravating features which support that starting point. And various features interlink in this case, and to use a shorthand, I think they've been pointed out by Mr. Meehan as points 4, 5 and 6. Some horrific features of this offending, such as the use of restraints and the use of a weapon, be it a pole or a mobile phone. Those are two examples of items used by Mr. Sharif. The learned judge correctly described the appellant's mitigation as significant and later suggested that the impact of much of it was limited. My lady, we say it was both substantial and significant, and it was not properly reflected in the final determination.
What's the significance of saying substantial and significant? What's the difference? Substantial and significant versus significant? Right, okay.
There was plenty of mitigating features in her case. And more than that, her mitigating circumstances go to the very heart of why she became entangled in such a dysfunctional relationship, why she stayed in it, and why she, as the judge said, became so used to Urfan Sharif's appalling treatment of Sara that she became complicit in it and, I recognise, actively participated in it. Briefly, my lady, we invite the court to find that the following features, properly identified, of course, by the judge, merited more recognition. Number one, the coercive and controlling nature of the relationship with a man who was considerably older than her. My lady, of course, will be aware, and my lords, of coercive relationships being specifically allowed for in the bench book. It is very unlikely, looking at this young woman and the nature of her past, that she would have come before the courts for offences such as these, as horrific as these, towards a child, had she not been in that relationship. And she was vulnerable when they met, only 20 years old, with a history of depression and isolated from her family as a result of honour-based abuse. That family, my lady, her own mother and sister, further encouraged her to stay in the relationship when she told them about his abuse of Sara. She was trapped, she felt, and despite attempts to leave and seeking legal advice, she stayed. And it was in those circumstances, whilst looking after 5 other children, that she became involved and complicit and participated in this offending. My lady, in the final careful analysis of her particular circumstances, we invite the court to conclude that the sentence imposed is simply too long, that it does not justly reflect her role and her particular culpability and her significant mitigation. My lady, may I assist you any further?
You've been very clear and helpful. There are a number, and this is no criticism, far from it, but do we take it that you maintain all of the points in your written submissions?
I do.
Thank you.
Thank you.
Thank you very much indeed. Yes, Mr. Ivers.
Great. My lady, my lords, this is an appeal by Faisal Malik.
It's an application for leave.
An application for leave, sorry. In relation to the 16-year sentence passed upon him
Yes.
for an offence under Section 5 of the 2004 Act,
Yes.
causing or allowing the death of a child. Can I firstly, just dealing with the parameters of what the evidence was, quote from the learned sentencing judge from page 4 of the transcript, in terms of what, and it's 4E, what evidence there was to inform the decisions around sentence. The only credible evidence of events from 2019 until the period immediately before Sara's death comes from 3 sources. First, they are recovered WhatsApp messages that were sent by Beinash Batool to her sisters. Second, there is evidence from the family's neighbours and from teachers, staff and a parent at Sara's primary school. Third, there is evidence that you, Urfan Sharif, gave after you had abandoned the lie that you'd never assaulted Sara. Your evidence must, however, be regarded with a great degree of scepticism, since even after you'd made admissions, you continued to conceal the true extent of your cruelty towards Sara, and you were not truthful about the involvement and knowledge of the others. I think you might easily add to that list of 3 the various scientific and medical evidence, which was undoubtedly before the court in what was an extremely thorough investigation, as you can imagine it would be. The result of that investigation and those factors in relation to Faisal Malik, I deal with the learned judge's conclusions at paragraph 7, it's page 3 of the application. The judge sentenced the applicant on the basis that he did not cause Sara's death, but rather failed to take reasonable steps to protect her from the risk of serious physical harm being caused to her. Next, he could not be sure that the applicant played any active part in the ill treatment of Sara. He observed that there was no evidence at trial he had done so. C, much of the abuse of Sara took place before the applicant arrived in the UK in December 2022. And lastly, that the judge could not be sure that the applicant was present for all of the assaults on Sara. Indeed, he was sure that he was not. What was left then, and we don't, contrary to what the respondent's notice says, that we don't accept the factual findings, far from it, we do accept the factual findings. As I put it in paragraph 12, the problem is, having made those findings, we suggest the sentence arrived at did not properly reflect them. And so what it was left with is that he must have had knowledge of a number of very serious assaults, because he was living at a relatively small address and he was spending time at that address outside of term time. In terms of actually which of the assaults he was actually aware of or not, it was impossible to say. The reason I mention the evidence is that if in fact he had been part and parcel of the assaults, it was inconceivable, bluntly, that that wouldn't have emerged either from the messages where things were being discussed or from the rest of the evidence in the case. So it's a finding the learned judge made, and not a surprising finding that he made in relation to the Faisal Malik hadn't caused any of the injuries. There was bluntly no evidence he had ever laid a finger upon her. Now, there are, of course, sentencing guidelines in relation to Section 5. Perhaps counterintuitively, as most people looking at it would say, well, if you cause a death, if you cause an injury, then that is more serious than allowing an injury. But the reality, perhaps, of the sentencing guideline is the genesis of Section 5. Section 5 was passed in 2004 to, quote, intend to solve the problem that arises when a child or vulnerable adult suffers an unlawful death, and it can be proved that one or more of a small group of people living in the same household as the victim caused the death, but not which of them.
That wasn't a problem here.
No.
So that's right. So what...
No, but it just may be, I just suggest, it may be that because of where the Act came from and the problem it needed to deal with, that might explain why the sentencing guideline, rather counterintuitively, doesn't set out a distinction between causing...
Well, I think Lennon helps us here, doesn't it?
It
because
does.
it says in terms, look, the guideline on its face makes no distinction, doesn't presuppose a difference, it will all turn on the facts.
It'll all turn on the facts, exactly.
Your submission is on the facts. There was a distinction to be drawn between allowing and causing.
There was.
Facts here. On
the facts here. And if you start at the top at 18, and the appellant has received a sentence of 16, even though he didn't cause any injury at all, that's the first point we make. If you start at that end, you then ask the question, well, what sentences might have been passed? But more, what I suggest is gleaned from Lennon. And again, I know the respondent's notice simply says, well, it's on its own facts, which is often said about many cases. But we are here dealing with a relatively rarely, convictions for Section 5 aren't that common. In terms of thinking about the different levels of culpability in and around that particular section, there aren't a plethora of examples in the way that there is for homicide generally. And so when one looks at Lennon, the fact is that in Lennon, and I deal with this at paragraph 15, quoting paragraph 19 of the judgment in Lennon, there the applicant convicted of the Section 5 offence had actual knowledge of all of the assaults.
Wasn't it over a period of 14 days in Lennon?
Yes, it's a shorter period. Yes.
I mean, massively shorter.
Yes, I agree.
Lennon
yes.
it was the mother in Lennon. Yes.
Yes.
Okay. Mm-hmm.
Yes. In fact, it's not. I'm not using Lennon as a cross comparison. It just may illuminate some of the decisions that the learned judge made. So the first of those decisions is that it was the extreme nature of the failure to report that lifted the matter from 1B to 1A, so the extreme nature. If you then look at what had happened in Lennon, the applicant there, who was fully aware of the assaults, who was discussing them openly with the person who was doing them, where the torture chamber is noted, looking like a madman because of the number of bruises, but then went on to put forward false accounts of accidental injury and claims of improvement in the child's condition, lied to a close friend who saw Jacob at a time when the applicant herself described the head as looking like a basketball, lied to another friend who sent a photograph showing the bruised face, and then crucially, a few days before the fatal incident, lied to a social worker in order to avoid a planned visit at which the severe bruising of Jacob's head and face would have been observed. I venture to suggest that if you were looking for an extreme example of failure to report, the sorts of extreme examples of failure to report might be cases where somebody's actively covering up, actively taking measures to ensure that what is happening is not being found out.
There is no definition of extreme,
No.
nor is one helpful. I mean, what is extreme here is I think there are 6 out of 7 high culpability factors present. Prolonged and or multiple incidents of serious cruelty, gratuitous degradation, use of very significant force, use of a weapon, deliberate disregard for the welfare, failure to take any steps to protect.
Yes.
That's what was permitted here over months.
Yes.
And the most extreme part of this offending, I think everyone agrees, happened in the last weeks of this poor little girl's life.
The most extreme acts did occur at that point. There were clearly assaults which were occurring prior to that. There was what was happening in that house had gone on for a very long time before my client had arrived at the address.
Yes.
He had, until he had finished the course at Portsmouth, been bluntly away for nearly all of the time that he would have had anything to do with Sara, because he was there at the university and working in McDonald's when he wasn't at the university. So actually he was out of the house for a very significant period of time.
But you accept the findings that he was aware of the campaign of torture being perpetrated against Sara?
Yes, I have to accept that. I do. But not all of it. That's quite clear. And as the learned judge properly made clear, he was sure, in fact, that he was not present for all of it.
Wasn't it by May of 2020 that his term had finished at Portsmouth? Was he commuting on a daily basis, or was he living?
He was going there, I believe it was 3 or 4 times a week. And then he was there for most of the day. And then he was able to work, because you had a particular number of hours that you could fill in under a visa. So he was working at McDonald's for much of the rest of the time. But I do accept that once that term stopped, he would still be working in McDonald's, which was nearby.
20 hours a week.
Yeah, exactly. But taking other time where he would be either at home or he was seen on local CCTV. There wasn't much of it because of the area that it was. It wasn't like
So he was back in the home from May, June, July and August when she was killed?
Yes, indeed.
Back in the house?
Yes, indeed. And so I'm not suggesting that he wasn't there during, or therefore much of the time during the period when such assaults would be taking place. But it does not follow that he must have been present for all of the very worst kinds of assaults that took place. There is simply no evidence that he was, and the learned sentencing judge didn't find that he was either. In fact, found the opposite. And it's just whether or not, having regard to that, combined with, as I say, Lennon I wasn't using as a comparator. She received a sentence of 10 years, whereas Mr. Malik received a sentence of 16.
You're not using it as a comparator?
No, I'm not using it as a comparator because also in Lennon there were issues concerning the applicant herself, etc.
Yeah.
But it is an example of allowing, and it is an example of how far allowing can go, and most right-thinking members of the public might regard somebody that's actively covering up again and again for assaults that are taking place to be more culpable than somebody who's not. That is not to say that it is not an extremely serious offence to allow in the sense that my client allowed. But in point of fact, it is less culpable, in my respectful submission, than somebody actively covering up. And that's the distinction.
Could you remind me, when your client arrived here, the family was still living in the flat?
They were...
And when did they move to the house?
April.
Thank you.
Yes. So I accept that temporarily there is a longer period, significantly longer period, than in relation to the applicant in Lennon. But in terms of knowledge of what was happening, that needs to be taken into account. And secondly, the nature of allowing needs to be taken into account as well. And the simple submission that we make is that it wasn't sufficiently taken into account, that it was that species of allowing, as opposed to the species of allowing, which takes active steps to prevent assistance. That's how I put it.
Thank you very much indeed. And Mr. Taylor, nothing, you don't wish to follow. Thank you. Yes, Mr. Little.
My lady, can I just deal with 3 short matters, and then I think Mr. Lloyd may follow in relation to the causing or allowing count. To the extent that you may want my assistance on this in relation to the whole life order and an intention to kill, the point that you made to Mr. Mian, my lady, I would submit that it could be a relevant consideration, but it doesn't have to be. For example, in Cousins, there was a conditional intent, but not an intent to kill before he went out. Every case will turn on its own facts, but I wouldn't be so bold as to say that it could not be, or that it had to be a requirement.
It's not a requirement, but it might be a relevant factor.
Second, and this is a point that to a certain extent my lady's already made to my learned friends, the judge was clear that he was not going to and was seeking to avoid double counting. And another way to articulate this point is to say, but sometimes when there is such an accumulation of matters or the extent of a particular feature that it counts both in terms of what I would call categorization in a non-Schedule 21 case or in a Schedule 21 case, and it has to count. So one has to avoid double counting, but one sometimes has to be careful to ensure that matters properly assessed count above and beyond where a starting point may be. And lastly, and to the extent of drawing the ire of the court to refer to Tustin yet again, can I just make this quite important factual point? The conduct was less than 3 months in Tustin. 23rd of March when they went into lockdown, and then the child had been well looked after in different circumstances before then, died on the 17th of June. So real care needs to be taken with the submission that has been made that somehow Tustin is in any way a comparable case. The other important aspect about Tustin was that the criticisms that I were making obviously were not upheld by the court, but a large amount of the features that drove the judge to go to the 30-year starting point, he regarded as being baked into that starting point. This judge took a very different view as far as that was concerned, and that's why this is a very good example of why Tustin is not a properly analogous case for this court to look at. It's not a case that sets out any bright line of principle in relation to Schedule 21, other than it reflects the fact that my submissions weren't accepted by the court. But on its facts, that particular judge decided that the balance between aggravating and mitigating features beyond 30 took the case just below 30. Here, this judge took a different view about the balance of aggravating and mitigating features as far as Beinash Batool was concerned. And in our submission, that is very much ordinarily a matter for a child judge, that balance, unless the balance that they have exercised is one which is Wensbury unreasonable. And in our submission, that isn't the position here as far as Beinash Batool is concerned, nor as far as Mr. Sharif is concerned. But unless the court would wish any further submissions on what I would call the whole life and Schedule 21 aspects of the case, I have nothing further to add.
Anything you'd like to say about causing and allowing? On the facts, is it your position that there was a difference? Oh, forgive me, Mr. Lloyd.
I'm so sorry, Malik.
No, no. Yes.
On that application, we submit that the judge, on the basis of the findings of fact that he came to, properly applied the guideline, which within that guideline it caters for movements in terms of assessment of culpability, and in particular, so far as the first category is concerned, I don't know if my lady and my lords have it to hand, but as part of the high culpability features, that they include a failure to take any steps to protect the victim.
Yes.
And it would be through that, and perhaps other categories, but through that, for example, that the judge would calibrate whether this is a case of causing or allowing, if it's necessary to do so. So the judge plainly had in mind that aspect of culpability in this case.
I'm just trying to work out what your position is. Is it that, on the facts of this case, there was no distinction to be drawn between causing or allowing, or, on the facts of this case, there was a distinction to be drawn between causing or allowing, and the judge properly respected that distinction in the sentence that he imposed?
Yes, well, he properly respected that in the sentence he imposed. I'm bound to say that this is the circumstances of this case are one where the judge wouldn't have been wrong if he'd said that the allowing offence in this case is more serious than other examples of causing, and that's what the reference in Lennon is referring to. That there can be cases where, in fact, an offence of allowing is more serious than causing. It depends on the circumstances. Yep. But as the court has already referred to, when one looks at the judge's analysis, it's at paragraph 29, or beginning at paragraph 29 of his remarks. He deals, in fact, with all of the points that really are now sought to be relitigated by the applicant. Paragraph 29, he deals with the presence of the applicant at the address, so he has that well in mind in terms of being at university, but then term ending in the May of 2023, and the judge found on the evidence that he spent the bulk of the time in the house, apart from spending 20 hours a week working shifts and so on. And then paragraph 30, so far as his culpability is concerned, the judge, as a finding of fact, found he had no doubt whatsoever that Malik was aware of the campaign of torture that was being perpetrated. And he observes the house and flat were too small, too overcrowded for there to be any other realistic conclusion. He then refers to the extent of the injuries, victim of many assaults, in the home, especially in the last weeks. And importantly, the judge then found it's inconceivable that you were not around for any of them, or you did not see or hear anything, or that you were unaware that she was being tied up. The idea that was at one stage put forward on your behalf, that you were too busy on your phone to notice anything happening is preposterous. And importantly then, so far as presence for all of the assaults is concerned, the judge dealt with it in this way at the end of that paragraph. I cannot be sure that you were present for all of the assaults. Indeed, I'm sure that you were not, but you were present for and well aware of a substantial number of them. And so having made those findings, he was perfectly entitled and correct to alight upon the very highest category. It's also then returned to, so far as the remarks is concerned, paragraph 70. Paragraph 70 is where the judge is dealing with the guidelines, and he makes it clear he's sentencing on the basis you did not yourself cause Sara's death, but your offending consisted of failing to take reasonable steps to protect Sara from the risk of serious physical harm. And he goes on, I cannot be sure you played any active part in the ill treatment of Sara, and indeed I do not believe that you did. But then he goes on at paragraph 71 to again set out what the applicant would have been aware of. And that includes, in the final part of paragraph 71, you cannot fail to have been aware of much of the terrible ill treatment which was regularly being meted out, including beatings, burnings, tying up and hooding of Sara with tape and plastic bags. So the judge, as a matter of fact, found that whilst he wasn't present for all of the assaults, he was aware of that sort of conduct taking place. And so again, if we return to the guideline, the judge was perfectly entitled and correct, in my submission then, to having made those findings, to place the case within very high culpability A. I'm bound to say it was done on the basis of the extreme character of one or more of the culpability B factors, but it would also be in A on the basis of a combination of the culpability B factors, because, as the judge observed, almost all of the B factors were present.
Well, he did both, didn't he, the judge? He said it's both by the extreme character and or by the presence of a combination.
Yes, precisely.
So he went for both.
So on either or both bases, the case is plainly in A. And as I've already submitted, in another case, if there was to be an adjustment on the particular facts of a case to take account of whether it was causing or allowing, the guidelines provide a route for that to happen. But this wasn't a case where there was any justification for such an approach. And if that's right, and the applicant in his grounds in effect concedes that the judge was entitled to be in category 1A, they submit it should have been towards the lower end, but there's a concession that 1A was available. If that's right, then the judge's starting point was 14 years before then looking at the aggravating features. Can I deal very briefly with two other matters that are raised in support of the application? The first relates to the submission that the applicant, Malik, was not in the home before, of course, he arrives in the December of 2022. That's, of course, correct, and the judge had regard to that. But the indictment period ran from December 2022 precisely for that reason, because it's then that Mr. Malik arrives in the home, and so he was sentenced for his knowledge of events from December 2022, which, as the judge observed, was a period of some 8 months. That leads me on to the second matter I wanted to briefly deal with in the case of Lennon. The court has already made some observations about the facts of that case, but it's plainly a very factually a very different case, and of course that was an application for leave to appeal which was refused. It isn't a case in which the court considered the substance of the appeal, as it were. That was offending over a matter of weeks compared to the 8 months in this case. In that case, the applicant had in fact called 999, different to this case, of course. There was no contact to the authorities, and there was some mitigation that the judge had regard to in that case, which plainly wasn't available to the applicant in the present case. I'm bound to observe that in that decision, the court in Lennon upheld or said that the judge's approach to categorisation was justified. That was the case placed in category B, but the court in refusing leave noted that there were a number of factors that fell into culpability B, and so arguably in that case the judge could have gone up to category A. He didn't, and the court said the sentence was not manifestly excessive. But looking at the analysis of the judge at first instance in that case, it seems that it would have been open to the judge in that case to have gone up to a higher category based on the multiple category B factors. For all those reasons, the decision in Lennon is of no assistance whatever, I respectfully submit to the applicant.
Mr. Lloyd, isn't there an additional point as well? That on the facts of Lennon, the offence occurred before the increase in sentence. So it had to be sentenced on the basis the maximum was 14 years.
Well, my Lord is quite right. That in fact, that was dealt with by the court. Paragraph 15, it's in the authorities bundle at page 195. It's the CACD 1, page 605, internal bundle, page 195.
It's also, I think, in paragraph 18.
And what did the court say?
Yeah, so it's raised at paragraph 15, where the applicant was submitting there should have been an allowance made for the increase in the maximum penalty. And the court, at paragraph 18, in fact, held or observed that, in fact, the guidelines still ought to have been applied.
That's a guideline, but still, the sentence of the judge was obviously within the then existing maximum.
Yes, so precisely.
10 years against the maximum 14.
Yes.
And, of course, that's a different position than this case.
Yes, precisely. Since the offence was committed in that case, the maximum has been increased. And what the court is saying at paragraph 18, referring to AZT, is that the guideline had to be applied, provided the judge isn't imposing a sentence that would be beyond what was then the maximum. So in that case, the judge couldn't have gone past the 14 years, even if the guideline had suggested that the judge...
Surely that means you couldn't, as it were, take the starting points in the guideline in the same way.
Yes.
You take the approach in principle,
yes,
identification of culpability factors and harm factors, but the numbers
yes, precisely,
needed to be calibrated.
Precisely, and exactly. So it's not a question of going back to an earlier guideline. It's applying the current guideline, but of course, as my Lord observes, one cannot then impose a sentence above the maximum that was in force at the time.
Thank you.
I don't think there's anything else I can do.
No, anything else? No. Thank you all. Yes, Mr. Ivers.
One thing very
Please.
clear.
Yes.
Which is that it was never suggested as part of the sentencing hearing for my client that in some way he was completely unaware of what went on because he happened to wear earphones, etc. It was a reference, there was a trial, and of course we were on trial for murder and manslaughter as well. We adduced evidence from messages from Beinash Batool to her sisters shortly after the defendant, Mr. Malik, had arrived from Pakistan, effectively complaining that he's always on the phone, that he's always listening to music, he's always got his headphones in, and that there were many times, or every single time actually, that he was seen on CCTV in the area, he was always having his headphones in. It was simply that during a trial when we were charged with murder and manslaughter, we were not and never did suggest that he should be sentenced on any other basis than he was guilty of Section 5, and we didn't and don't seek to relitigate the points made by the learned sentencing judge. As I've acknowledged, he was entitled to make them, and indeed he made those positive findings in relation to the fact that we couldn't have been there for all of it, etc. It's just our point we make about where the sentence ended up. It's not really
Understood. Thank you very much. No, I think we understand that. Thank you very much indeed. Well, thank you all again. We will retire. I think that our best estimate is that we would like to give judgment, if we can, today at 2 o'clock. Let me just check with my lords. Yes. If that changes because we are unable to reach a decision or we have inadequate time to prepare, we will let you know. But our present intention is to come to court at 2 o'clock to deliver our judgment both on the reference and on the applications for leave and appeals to follow if leave be granted. There is a separate question which relates to access to documents. Mr. Little, an issue that we have traversed recently. Yes. Asked the parties to consider whether or not it would assist members of the public or the press if there could be access to the respondent's notice and grounds of appeal, if that's of any interest. Perhaps there could be some engagement with the press on that and an agreement reached if necessary. There may be no interest in any further documents, but if there is, we stand ready to assist, and perhaps the matter can be dealt with consensually in any event. Are there any other matters that you would like to draw to our attention?
No, could I ask that my junior is released because he is required back at the Central Criminal Court for 2 o'clock, but I will be here at 2 o'clock.
Of course.
Thank you, my lady.
Does 2 o'clock present any difficulties for any other members of the bar?
No, my lady.
Thank you all very much. An order under Section 45A of the Youth Justice and Criminal Evidence Act 1999 is in place in respect of a number of witnesses who are under 18. Restrictions imposed under Section 45A in respect of a victim or witness apply for life. Introduction. The Registrar has referred these 3 applications for leave to appeal against sentence to the full court. The applicants are the father, stepmother, and uncle of Sara Sharif, who died on the 8th of August 2023 at the age of 10. On the 11th of December 2024, Sara's father, Urfan Sharif, and stepmother, Beinash Batool, were convicted following trial before Mr. Justice Kavanagh and a jury of Sara's murder. On the same day, Sara's paternal uncle, Faisal Malik, was acquitted of Sara's murder, but convicted of causing or allowing her death, contrary to Section 5 of the Domestic Violence, Crime and Victims Act 2004. The applicants were sentenced by the judge on the 17th of December 2024, with technical adjustment following a slip rule hearing on the 23rd of December 2024, as follows. Sharif, imprisonment for life with a minimum term of 40 years, less time on remand, meaning a period of 38 years and 271 days specified as the minimum term under Section 322 of the Sentencing Act 2020. Batul, imprisonment for life with a minimum term of 33 years less time on remand, meaning a period of 31 years and 271 days specified as the minimum term under Section 322 of the Sentencing Act 2020. Malik, 16 years imprisonment, less 459 days spent on remand in custody. There is also an application by His Majesty's Solicitor General for leave to make a reference under Section 36 of the Criminal Justice Act 1988 in respect of the sentence imposed on Sharif. On an appeal or a reference by the law officers, this court will not substitute its own assessment for that of the sentencing judge. This court will interfere only if the sentence in question was manifestly excessive or unduly lenient, as the case may be. So the questions for us, in the first instance, are whether, 1, the sentence imposed on Sharif was arguably manifestly excessive or unduly lenient. 2, the sentences imposed on Batul and Malik are arguably manifestly excessive. The facts. The relevant facts of this tragic case are well known, and we summarise them only briefly. Sara was born on the 11th of January 2013. For the first few years of her life, she lived with her mother, her older brother, and one of her mother's sons from a previous relationship. In 2014, Sharif began a relationship with Batul, and by early 2015, he and Batul were living together in Woking. Until June 2017, Sharif only had supervised contact with Sara and her brother. From then until March 2019, Sara and her brother would stay with Sharif and Batul on weekends and during school holidays. In March 2019, Sara and her older brother made allegations of abuse at the hands of their mother, following which they moved in with Sharif. Sharif was later awarded custody of both children. In January 2016, Batul had given birth to twins. As the twins, who had behavioural issues, grew older, they became very challenging. In December 2018, Batul gave birth to a son who suffers from ill health. In July 2022, another son was born. So by July 2022, the family consisted of 2 adults and 6 children, including Sara. They lived together in a small flat in West Byfleet from 2017 until April 2023, moving then into a 3-bedroomed house in Woking. Sharif worked long hours as a taxi driver, and Batul stayed at home looking after the children. Sharif began regularly assaulting Sara soon after she moved into the family home, often inflicting serious violence on her. He designed unpleasant punishments for her, such as making her stand against a wall holding her arms up or making her do sit-ups. On occasion, he would wake her in the middle of the night to impose physical punishment on her. From the age of 6 or 7, Sara was made to do the washing and to hang it up. She had to tidy up the house and care for her youngest brother. She was singled out amongst the children for this treatment, there being no evidence of violence towards her older brother or her younger siblings. In general, neither Sharif nor Batul had any concern for Sara's happiness or her quality of life. She was treated as if she was worthless. No allowances were made for her age. In June 2022, and again in April 2023, Sharif removed Sara suddenly from school. He was concerned that the authorities would discover his ill treatment of her because of her visible signs of abuse. For some time, she was made to wear the hijab, and her whole body was covered up in order to hide the bruises that were all over her body. So Sara was not only subjected to despicable abuse, she was also being deprived of an education. Batul did not protect Sara and went along with Sharif's abuse. Indeed, she encouraged and assisted Sharif in some of his assaults. She cared less about Sara because Sara was not her own natural child. Batul could be heard by neighbours yelling and swearing at Sara. And although she sometimes put cream on Sara's wounds, Batul did not stop Sharif from hitting Sara, nor did she seek intervention to protect Sara, out of concern that, of course, if she did so, she might or would lose custody of all of her children. At times, she took active steps to cover up for Sharif. She sometimes put makeup on Sara's bruises to conceal them, and she went along with the decision to homeschool Sara. Sometimes she would call Sharif at work to summon him home, knowing full well that this would likely result in a beating for Sara. Sara began to vomit up food, and at times she soiled herself, and in response to this, Sharif assaulted her further. When Sara soiled herself, Batul would ask Sharif to come home to sort it out, knowing very well and intending that he would deal with it by beating the child. The assaults on Sara were carried out in front of the other children, or at least in locations where the beatings and Sara's screams could be heard by the other children. Sara's older brother was aware of the constant ill treatment of his sister, and this affected his own behaviour towards her. Malik was Sharif's brother and arrived in the household in December 2022. He had come from Pakistan to undertake a postgraduate course at Portsmouth University. From May 2023, apart from working at 20 hours a week at McDonald's, he spent the bulk of his time in the house. As for the last couple of months of Sara's life, the post-mortem evidence showed that when she died, she had at least 71 separate fresh injuries on her body, mainly bruises and abrasions in various places. There were also marks of older injuries. She had been beaten on her head, her face, her chest, her abdomen, and on each of her arms and legs. Some of the marks were consistent with being tied up, and many of the injuries had tramline markings showing that she had been beaten with an elongated object. Sharif admitted to beating Sara on a number of occasions with a metal pole and a cricket bat, and to hitting her on the head with a mobile telephone. In addition to the 71 fresh injuries, Sara also had 25 separate fractures, including a fractured collarbone, 2 fractured shoulder blades, fractured ribs, a fractured humerus, 11 separate fractures to her spinal column, and fractures to bones in both of her hands. These fractures were dated variously between 8 weeks before death and 2 weeks before death. They were the result of multiple episodes of violence, each involving a substantial degree of force. The medical experts identified a fracture in the hyoid bone in Sara's neck. That is a very unusual injury and was the result of very vigorous and energetic manual strangulation, quite possibly on more than one occasion. Sara also sustained a serious brain injury a few days before she died as a result of a blow to her head. She had 2 open burn wounds on her buttocks. These were in the shape of the sole plate of an iron and matched the iron that was found in the house. The wounds had undoubtedly been caused by her buttocks being pressed for several seconds against the hot plate of the iron. This would have required 2 people to carry out, one to hold the little girl down and the other to press her against the iron. This injury had been sustained between 2 and 6 weeks before death. Nobody had treated it, nobody had sought medical help. Had Sara lived, it would have caused permanent disfigurement. Sara had open burn wounds also on the bones of the inside of each ankle, indicating that her ankles had been tied, and then either her feet wrapped around a hot pipe, or more likely, boiling water being poured on her ankles. She also had 6 bite marks on her body, 5 on her left arm, and 1 on the inside of her left thigh, assumed to have been caused by Batul. In the last weeks of her life, Sara was tied up. She was trussed up with masking tape and skipping rope and hooded. Plastic bags were put over her head, held in place with masking tape, a hole being ripped in the plastic bag so that she could breathe. When the bins at the house were examined after her death, the police found a soiled nappy wrapped around her leggings, evidence that Sharif and Batul were putting her in pull-up nappies because they were not allowing her to go to the toilet whilst she was trussed up. Moreover, the medical evidence showed that Sara had been left in her own urine and feces, with restraints so tight that her feet and ankles were pulled up so that they were in contact with her bottom. She was underweight, she was undernourished. The cause of death was complications arising from multiple injuries and neglect suffered cumulatively, not specific to a single injury or incident. In the early evening of the 8th of August 2023, a Tuesday, Batul saw that Sara was very unwell. She called Sharif asking him to come home. When he returned, Sara was floppy in Batul's arms. Sharif proceeded to beat her vigorously with a metal pole on her abdomen for pretending to be ill. A few moments later, she died. Malik was in the house at the time. The three adults did not call for an ambulance nor the police. Rather, they made immediate preparations to flee to Pakistan with a view to abandoning Sara's body in the house. Indeed, within less than an hour of her death, they were arranging flights to Pakistan for the rest of the family. They then took steps to cover up what they had done. Sara's body was washed, put in clean clothes, placed on a bed. Her leggings, the nappy she was wearing, the masking tape, the hoods were put in bins. The metal pole was hidden in an outbuilding. Malik's McDonald's uniform was found partly in and partly next to the bins, alongside the other items, and part of the uniform was soaking wet. Sharif removed the Ring doorbell to hide any video evidence, and he left a note on Sara's body saying, "Whoever sees this note, it's me, Urfan Sharif, who killed my daughter by beating. I am running away because I'm scared, but I promise that I will hand over myself and take punishment." The following morning, Sharif, Batul and Malik drove the remaining children to Heathrow. They stopped on the way for Sharif and Batul to withdraw substantial sums of money in cash before fleeing to Pakistan. Upon their arrival at Islamabad, Sharif rang Surrey police, saying he had killed his daughter. Her body could be found at the house. He said tearfully, "I did legally punish my daughter and she died." He said he intended to hand himself in, but did not tell the police where he was. They all then went into hiding in Pakistan. On the 6th of September 2023, Sharif and Batul took part in a video press statement in which they referred only briefly to Sara, saying it was a, quote, incident, and then spent the rest of the time complaining about the pressure under which they were from the Pakistani authorities. On the 13th of September 2023, Sharif, Batul and Malik flew back to the United Kingdom. They were arrested on arrival and interviewed, all declining to answer questions in police interview. Sharif was 43 years old at the time of conviction, with one previous conviction in 2013 for an offence of employer theft. Batul was aged 30 at the time of conviction. She had previous convictions for 2 offences of theft and making a false representation. Malik was 29 years old at the time of conviction, with no previous convictions or cautions. Sara was a little girl full of personality, a beautiful, brave, feisty and spirited child who adored her younger brother. Her teacher described her as bubbly, confident, chatty and engaging, and she loved to sing and dance. The sentence. The judge proceeded to sentence without any pre-sentence report, and we agree that none was necessary. In careful and well-structured sentencing remarks, he described the campaign of abuse against Sara as torture and said that none of the applicants had shown a shred of true remorse. At trial, Sharif had blamed Batul for Sara's injuries until it became clear that his description of events simply had no credibility. He then asserted that he had not intended to cause any injury to Sara and that his admitted assaults were not the cause of her death. Malik and Batul remained silent at trial and had made no effort to accept any responsibility for their offending. Sharif. The judge stated that Sharif's offending did not come within the class of offending for which a whole life order would be appropriate. The way that Sharif treated Sara, culminating in her murder, was of such seriousness, however, as to warrant a 30-year starting point. Even if the word sadistic was not precisely apt to describe the offending, which did not fall with any of the specific examples in Schedule 21, for which a starting point of 30 years for the minimum term was appropriate, that list was not exhaustive. Sharif had plainly derived grim satisfaction from his campaign of violence against Sara. The judge then identified 3 statutory and 14 non-statutory aggravating factors. Statutory aggravating factors were Sara's particular vulnerability due to her age, the fact that she suffered extreme mental and physical suffering, mainly at the hands of Sharif, the assaults, which went on for 4 years, were accompanied by other acts of cruelty, which meant that Sara must have been in a constant state of terror. Sharif took Sara out of school to conceal what he had done. In the last few weeks, Sara was tied up, hooded, left to wallow in her own urine and feces and tortured. Thirdly, abuse of trust, though the judge bore in mind the overlap between the abuse of a position of trust and Sara's vulnerability. As for non-statutory aggravating factors, Sara had been singled out as a female child who was not Batul's child. Weapons and restraints had been used, and the assaults took place in front of or within the hearing of other children. When Sara was close to death, Sharif did not call an ambulance or seek medical help. He beat her with a metal rod. Following her murder, he fled abroad, went into hiding, then denied everything until 6 days into his evidence at trial. He disposed of evidence. He sought to blame Batul, which the judge described as a major aggravating factor. He had a history of preying on vulnerable women and had shown no real remorse, but was suffused with self-pity. The judge said the previous conviction was of no relevance. Whilst he had been careful to avoid double counting, a sentence of 30 years would not reflect the gravity of Sharif's offending. There was very little by way of mitigation. The judge accepted that Sharif did not intend to kill Sara, but this was scant mitigation in the circumstances. Batul. The judge said that Batul's involvement consisted mainly of encouraging and assisting Sharif in his assaults. She valued Sara less than her other children and was prepared to sacrifice Sara in fear of losing her other children. Batul had taken an active part in some of the maltreatment of Sara, biting her on the arm and inner thigh shortly before she died, taking part in the tying up and hooding of Sara. The judge had no doubt that Batul was involved in the burning of Sara with an iron. She sincerely expressed horror and concern in the early stages of Sharif's treatment of Sara, but did nothing about it and became complicit in it. The judge said that her conduct was of such seriousness as to warrant a 30-year starting point. The judge then identified the same statutory aggravating factors as for Sharif, with the same caution about overlap and the need to avoid double counting. As for non-statutory aggravating features, he identified the singling out of Sara for ill treatment as a female with a different mother, the use of weapons and restraints, the fact that the assaults took place in front of or within the hearing of other children, the deliberate concealment of the maltreatment, the failure to seek medical help, the fleeing to Pakistan, the abandoning of Sara's body, the disposal of evidence, the uprooting of her other children and stepchild from their home, and the lack of credible remorse. The judge then identified the following mitigating features, which he described as, quote, significant. Batul was not the prime mover in the assaults. Her role was a secondary one of assisting and encouraging Sharif, and she did display the occasional act of kindness towards Sara. Batul was in a coercive and controlling relationship. Sharif was considerably older, and she felt under pressure to obey him and follow his lead. She was vulnerable when they met, and was the occasional victim of abuse by Sharif. She was under a great deal of strain as essentially the sole carer of 6 children in a flat and a house which were each far too small. The twins had challenging behaviour. She had had a difficult, strict and religious upbringing. She had been disowned by her own father, had a medical history of depression, and was effectively of good character. However, the judge said the impact of the mitigation was limited. Batul had a strong character and could have stood up to Sharif in relation to his treatment of Sara. She should have taken steps to stop the torture of Sara, but instead took a positive decision not to seek help. She had not intended to kill Sara, but this again was scant mitigation. Malik. The judge stated that Malik's offending consisted of failing to take reasonable steps to protect Sara from the risk of physical harm being caused to her by the unlawful acts of Sharif and Batul. There was no evidence that Malik had played an active part in the ill treatment of Sara, but he could not have failed to have been aware of much of the terrible ill treatment, yet he stood by and did nothing. He was present for and well aware of a substantial number of the assaults on Sara during his time with the family. The judge placed the offending in category 1A with very high culpability and with a starting point of 14 years imprisonment and a range of 12 to 18 years imprisonment. The judge said that Malik's failure to protect Sara was extreme. The judge identified as aggravating factors the prolonged and exceptional suffering endured by Sara, recognising the need to avoid double counting, the fact that the offences were committed in the presence of other children, the failure to seek medical help, the fact that Malik had helped the family to flee to Pakistan, the disposal of important evidence on Malik's mobile telephone, and the lack of remorse. As mitigating features, the judge identified Malik's previous good character and the fact that much of the abuse took place before Malik arrived in the United Kingdom. The judge concluded that Malik did not meet the criteria for dangerousness. Grounds of appeal against sentence. Sharif. It is accepted for Sharif that whilst not falling within any of the non-exhaustive categories identified in paragraph 3.2 of Schedule 21, the judge was entitled to take 30 years as a notional starting point before considering aggravating features. The first ground of appeal is that the judge must have double counted some of the aggravating features. Mr. Meehan, King's Counsel, submits that having taken the 30-year starting point because of the nature of the overall offending, the court had to be astute to avoid double counting. Whilst the sentencing remarks show that the judge was alive to the risk, in the results it is suggested that he failed to avoid it. It is said by reference to the 3 statutory and 11 non-statutory aggravating factors which the judge identified, the judge in effect double counted. The mental and physical suffering inflicted on Sara before death, the singling out of Sara amongst his children for harsh treatment, the use of weapons, restraints, the particular conduct on the 8th of August. The judge, Mr. Meehan, submits that the uplift to 40 years can only be explained on the basis of inadvertent double counting. In summary, it is suggested that the pre-death conduct relied upon by the judge in order to reach a starting point of 30 years could not be used in any way as an aggravating feature to lift the term above 30 years. The second ground of appeal is that the judge took into account matters which should not have been treated as aggravating factors and/or gave such factors undue weight. So it is said to have been wrong to treat as aggravating factors the uprooting of the other children, the placing of blame on Batul, and the lack of remorse. As to the uprooting, this presupposed without supportive evidence that they would have been better off here, almost certainly split up from each other, rather than with their family in Pakistan. As for blame on Batul, it's said to have been wrong to treat this as a major aggravating factor. Placing blame on others was capable of being such a factor, but this was typically in circumstances where the blame is being placed on an innocent person. As to remorse, its presence was a mitigating factor, its absence was not an aggravating one. Finally, it is suggested that the judge failed to give sufficient weight to the mitigating factor of absence of intent to kill. The combined result of these errors is suggested to have resulted in a manifestly excessive minimum term of 40 years. Batul. On behalf of Batul, Ms Carberry, King's Counsel, does not challenge the judge's starting point of 30 years, but submits that once selected, that term should have been the ceiling of the minimum term, not its floor. She submits, firstly, that the judge failed sufficiently to recognise that Batul's culpability was significantly less than that of Sharif, and secondly, that the judge laid too much weight on aggravating factors and too little weight on mitigating factors. As to culpability, Ms Carberry points to the fact that Batul had a secondary role only in the assaults. It is suggested that having accepted that Batul was not the prime mover in the assaults on Sara, the judge then undermined that mitigation by going on to state that she did take part in inflicting some horrible injuries on Sara. Further, it is suggested that the judge wrongly identified that Batul had sometimes participated in acts of extreme cruelty over a long period, when Batul's participation had only taken place towards the end of the campaign. As for aggravating features, it is suggested again, as with Sharif, that whilst the judge clearly had the risk of double counting in mind, he failed to avoid the trap and must have double counted aggravating features in relation to mental and physical suffering, the use of weapons and the use of restraints. As for mitigating factors, too little weight, it is suggested, was placed on Batul's history of domestic abuse within the childhood home, honour-based abuse in her teenage years and isolation from her family, lack of support, guidance or advice from her family, and extreme cultural pressure being placed on Batul. Ms Carberry emphasises that Batul was only 20 when she met Sharif, a man 13 years her senior, and had a history of depression. It is also suggested that the judge failed to place adequate weight on the absence of an intent to kill. The first ground of appeal builds on the the final ground of appeal builds on the first and second, and contends that the minimum term should have been reduced below the 30-year starting point, and accordingly the term of 33 years was manifestly excessive. Ms Carberry, in writing, sought to support these submissions by reference to a number of other cases considered by this court, seeking to draw a contrast between the minimum terms there imposed and the present. We say immediately that we have not been assisted by the citation of these cases. The attempt to draw on supposed similarities and distinctions to and from the present case has not been relevant, when each case is inevitably and particularly dependent on its own facts and circumstances. It is simply not a useful exercise. Malik. It is submitted for Malik that his sentence was manifestly excessive for the following reasons. First, that the judge adopted too high a category within the relevant Sentencing Council guideline. The categorisation should have been 1B, towards the top of the range, and not category 1A. Secondly, it is said that Malik should be sentenced only for what he could be proved to have known or witnessed, not on that which he could not. Thirdly, and in extension, it is said that the judge accepted that Malik had not himself caused any injury to the deceased, and that should have reduced his sentence further. Fourthly, it is suggested that many of the aggravating factors of seriousness did not apply to Malik, but they were nevertheless taken into account against him. Fifthly, the criticism is that the judge failed to draw a distinction that Malik did not cause Sara's death, he only allowed it. Sixthly, reliance is placed on the suggestion that if the sentences of Sharif and Batul are to be reduced, then so should the sentence of Malik. In the course of his oral submissions, Mr. Ivers, King's Counsel, emphasised in particular that the nature of Malik's offending, namely that it was allowing rather than causing the death of Sara, was not taken into account adequately, Furthermore, the nature of the allowing was not to be treated as extreme as, for example, might be the case where active steps are taken by an offender to conceal the offending in question. Grounds of opposition. In summary, it is said that none of the sentences imposed in this case can properly be described as manifestly excessive. The judge who heard the lengthy trial was right to describe Sara's death as the culmination of years of neglect, frequent assaults and torture. The judge's approach to sentencing had regard to the relevant sentencing framework in relation to each applicant, based upon the judge's assessments of the facts as he found them to be. It is submitted that none of the grounds raised are arguable. Reference under Section 36 of the Criminal Justice Act 1988. The Solicitor General submits that the judge was wrong not to impose a whole life order on the offender. The Solicitor General recognises the advantage of the trial judge in assessing seriousness of the offending. It is emphasised that Schedule 21 is, however, not a straitjacket. There must come a point at which the balance tips in favour of a whole life order, even if the facts do not strictly fit the non-exhaustive examples given in Schedule in paragraph 2. This was, it is said, a truly awful case of the murder of the child. Given the judge's findings of fact as to the extent, the nature and the duration of the offending, this was a case, it is suggested, where only a whole life order could be imposed. It is said that the judge dealt only briefly with this issue when he could and should have said more as to why he was not imposing a whole life order, given the findings of fact that he was making. It is suggested that it is difficult to conceive of a murder being perpetrated on a young girl by her own father that could be any more serious. There was not an intention to kill, but the judge, it is suggested, rightly regarded that as scant mitigation. The categories, it is emphasised by Mr. Little, King's Counsel for the Solicitor General in Schedule 21, paragraph 2.2, are not exhaustive. And it is difficult, in the alternative, to see in principle why a case that merits the description of torture should be regarded as less serious, for example, than a murder involving sadistic conduct. Such sadistic conduct can be relatively short-lived and still meet that threshold. Indeed, here, the judge found torture and grim satisfaction on the part of Sharif from his campaign of violence. Having summarised the facts and the respective arguments, we first set out the relevant sentencing framework for murder and then our separate analysis in relation to each applicant. Relevant sentencing framework. By reason of Section 1.1 of the Murder, Abolition of Death Penalty Act 1965, an offender who is convicted of murder must be sentenced to imprisonment for life. However, when imposing a life sentence, it is also necessary for the court to make an order under Section 321 of the Sentencing Act 2020, which by subsection 2 must be a minimum term order, enabling the parole board to consider whether it is no longer necessary for the protection of the public that the offender should be confined after the conclusion of the minimum term, unless the court is required by subsection 3 to make a whole life order, in which case the early release provisions of Section 28(5)(8) of the Crime Sentences Act 1997 are not to apply to the offender. In the case of an offender who was aged 21 or over when they committed the offence of murder, the court must make a whole life order if, quote, the court is of the opinion that because of the seriousness of 1, the offence, or 2, the combination of the offence and 1 or more offences associated with it, it should not make a minimum term order. In considering the seriousness of the offence, or a combination of the offence and 1 or more offences associated with it, either for the purposes of determining whether to make a whole life order or determining the minimum term, the court must have regard, under Section 322(3) of the 2020 Act, to 1, the general principles set out in Schedule 21, and 2, any sentencing guidelines relating to offences in general which are relevant to the case and not incompatible with the provisions of Schedule 21. Schedule 21 sets out a series of starting points for the court's determination as to whether to impose a whole life order or a minimum term order, and in the latter case, the length of the minimum term. Paragraph 2 of Schedule 21 provides for the circumstances in which the starting point is a whole life order, materially as follows. Quote, 2.1, if A, the court considers that the seriousness of the offence, ... is exceptionally high, and B, the offender was aged 21 or over when the offence was committed, the appropriate starting point is a whole life order. 2. Cases that would normally fall within subparagraph 1A include A, the murder of a child involving a substantial degree of premeditation or planning, where the offence was committed on or after the day on which Section 125 of the Police Crime Sentencing and Courts Act 22 came into force, in square brackets, 28th of June 2022. Paragraph 3 of Schedule 21 provides for the circumstances in which the starting point for the minimum term is 30 years, namely, cases involving offenders aged 18 or over when the offence is committed where the court considers the seriousness of the offence to be particularly high. Cases normally falling within paragraph 3 include cases of murder involving sadistic conduct. Paragraphs 7 to 11 of Schedule 21 make provision in respect of aggravating and mitigating factors. Having chosen a starting point, the court should take into account any aggravating or mitigating factors to the extent that it has not allowed for them in its choice of starting point. Detailed consideration of aggravating or mitigating factors may result in a minimum term of any length, whatever the starting point, or in the making of a whole life order. Aggravating factors include a significant degree of planning or premeditation, the fact that the victim was particularly vulnerable because of age, mental or physical suffering inflicted on the victim before death, the abuse of a position of trust. Mitigating factors include an intention to cause serious bodily harm rather than to kill. The principles relating to whole life orders have been considered recently and authoritatively by the Court in Crown against Stewart and others, 2022, EWCA Crim 1063, where Lord Burnett of Malden, Chief Justice, reviewed the statutory provisions and the relevant authorities, summarising the relevant principles at paragraph 19, which we do not need to rehearse here. The parties, during the course of written and oral submissions, referred us to various authorities, including the case of Tustin, which falls within the judgment in Stewart and others, and also Crown against Lennon, 2024, EWCA Crim 719. Even a cursory comparison of the facts of those cases reveals multiple material differences, confirming that there is in reality no useful illumination or guidance to be derived from them for our purposes. Analysis, Sharif. We take the Solicitor General's application for leave to refer first. Whilst the prosecution did not press for a whole life order, it did leave open the possibility of such an outcome, both in their written note on sentence and orally at the sentencing hearing. In any event, any concession by the prosecution at first instance is no bar to the law officers seeking to contend that the judge was wrong and duly lenient. But the prosecution approach may, of course, be relevant to whether it was unduly lenient not to impose a whole life order. As identified in Stewart at paragraph 19, a whole life order is a sentence of last resort for cases of the most extreme gravity, reserved for the few exceptionally serious cases where the judge is satisfied that the element of just punishment requires the imposition of a whole life order. The case must be exceptionally serious, even in the context of a murder case. If the judge is in any doubt as to whether this standard is reached, that may itself well be an indication that a finite minimum term is the appropriate disposal. To be imprisoned for a period of 30 years or more is a very severe penalty. Further, as identified in Stewart at paragraph 81, in some cases, probably rare, the seriousness of the offending may be regarded as exceptionally high, even though the circumstances of the case do not fall within one of the criteria set out in paragraph 2.2 of Schedule 21. The criteria are not exhaustive. It is common ground here that Sharif's offending did not fall strictly within any of the criteria. As set out above, the gist of the Solicitor General's argument is that Sharif's offending can and should properly be equated with two of the criteria in paragraph 2.2 of Schedule 21, and that accordingly anything less than a whole life order was unduly lenient. We recognise the force of the analogy drawn. The use of repeated, routine, serious violence on a child over such a lengthy period bears comparison with a single act of premeditated lethal violence, amounting to the murder of a child involving a substantial degree of premeditation or planning. Further, Sharif's conduct, described by the judge as a campaign of abuse amounting to torture, from which he obtained grim satisfaction, could be said to be of no less gravity than the murder of a child involving sadistic conduct. As the Solicitor General points out, in the latter case, the conduct, unlike in the present case, may be short-lived. But we are not persuaded that anything less than a whole life order was unduly lenient. The judge considered the imposition of a whole life order and judged it to be inappropriate. The fact that he did not give detailed reasons for his conclusion is unsurprising, given the prosecution's lack of emphasis on such an outcome at the sentencing hearing. Whilst the prosecution submitted that the imposition of a whole life order at least merited the court's serious consideration, it went on to submit that the contention that this was a murder of particularly high seriousness was one which could be said sensibly to apply to the particular facts of the case. First, whilst recognising always that the categories identified in paragraph 2.2 are not exhaustive, the facts of this case, terrible as they are, do not fall within those categories. The absence of planning or premeditation to that end does distinguish this case from a planned or premeditated murder. Equally, as the judge found, the case did not fall within the strict category of murder involving sadistic conduct. Further, in this case, there was an intention to cause serious bodily harm rather than to kill, and in this context, that was a material factor. Secondly, as the authorities demonstrate, it must remain a rare case where the court should impose the last resort of a whole life order in a case falling outside the identified categories. In considering whether or not the case should nonetheless have been met with a whole life order, we remark that this court should give very great weight to the assessment of the trial judge, who had heard the evidence in the course of a lengthy trial. He was thus in the very best position to make the overall assessment that he did. In all the circumstances, whilst we grant leave for the reference, we conclude that the sentence was not unduly lenient. We turn to Sharif's application for leave to appeal against sentence. We are here not persuaded that any of the grounds identified above, individually or collectively, provide any arguable basis to challenge the minimum term imposed by the judge. As for double counting, the judge expressly and repeatedly directed himself on the importance of avoiding that risk. On the facts of this case, as we have described them, the net uplift to a 40-year minimum term provides no basis for any concern that he failed to comply with that necessary self-direction. We reject the submission that there is some bright line to be drawn in relation to events before and after Sara's death. The sheer severity, the weight and the extent of the events pre-death entitled the judge, having reached his notional starting point of 30 years, to use those factors to go beyond that starting point without impermissibly double counting. As to aggravating factors taken into account, the judge was fully entitled to treat the uprooting of the other children as an aggravating factor. They were born in the UK and in education here. The judge likewise rightly took account of the attempt to place the blame on Batul in the course of several days of evidence in the witness box before changing tack and beginning to take some limited responsibility. Conversely, we accept that the judge was wrong to include absence of remorse as an aggravating factor, but he did so as a reference only as an entry at the end of a very long list of other aggravating factors. In the context of the facts of this case and the overall sentencing exercise, we are sure that this can have had no material effect on the final minimum term which he imposed. As to the mitigating factor of absence of intent to kill, the judge clearly took account of it, but gave it limited weight. He was both entitled and right to do so. Standing back and looking at the overall result, we see no arguable basis to challenge the conclusion of the trial judge that 40 years was the appropriate minimum term for Sharif, and accordingly we refuse leave to appeal his sentence. Batul. We are also not persuaded that any of the grounds identified for Batul, either individually or collectively, provide any arguable basis on which to challenge the minimum term imposed by the judge. As for double counting, we again see no arguable basis to contend that the judge fell into error. He correctly directed himself to be on guard against double counting, and there is nothing in the ultimate minimum sentence to suggest that he failed to heed his own direction. Quite independently of the factors which justified the 30-year starting point, there were very substantial aggravating factors compelling a very substantial uplift before consideration of mitigating factors. Again, the judge was wrong to treat the absence of remorse as an aggravating factor, but in the overall context of this case, this would have made no material difference to the result. As for mitigating factors, we do not consider it arguable that the judge wrongly undermined his acknowledgement that Batul was not the prime mover in the assaults on Sara. The fact is that she did not play a purely secondary role in the sense that, in addition to her main role of encouragement and assistance to Sharif, she herself took direct part in inflicting some horrible injuries on Sara. She was involved in the two-person assault, in burning Sara's buttocks with an iron. She was involved in the biting. She was also involved in the tying up and the hooding. We would add that the written criticism that the judge somehow stated that Batul had participated in acts of extreme cruelty over a long period is a misreading of the sentencing remarks. A reading of them shows that the judge in fact stated only that Batul should have taken steps to stop this torture of a small child instead of encouraging and assisting, and sometimes participating in, acts of extreme cruelty over a long period. That statement contains no error. As to the personal mitigation, the judge identified and took account, including in the context of the relevant guidelines and the equal treatment bench book, of all the matters relied upon on this application. He was in the best position to assess the weight to be given to those factors. In summary, we see no arguable basis to conclude that the judge made any material error in the task of weighing up the aggravating and mitigating factors, nor therefore any basis on which to contend that the minimum term imposed was manifestly excessive, and again, leave to appeal against the sentence of Batul is refused. Malik. The first, second and third grounds advanced for Malik are linked and can be addressed together. As set out above, it is submitted that because it could not be proved that he was aware of all that was happening to Sara and that he did not himself assault her, his sentence should have been based on a Category 1B level of offending, or at its highest, at the low end of the 1A range of sentences. We do not agree. Here, there was the extreme character of the Category B factor, namely the extreme character of Malik's failure to take any steps to protect Sara. Further, there was a combination of Category B factors. All but 2 of the 7 high culpability factors identified in the relevant guideline applied to the offending allowed by Malik. The judge's clear finding on the evidence was that Malik was aware of what was happening, even if he did not know of each act of violence, cruelty, or torture. That raised his culpability. He did nothing to prevent it or seek help. As the judge found, he must have realised from what he did see and did hear that he was witnessing only part of it. By doing nothing, he allowed it all to continue until Sara died. In short, the judge was unarguably correct to sentence Malik on the basis of a Category 1A offence. The fourth ground is similarly based on the contention that, because it was not proved that Malik himself carried out the acts upon Sara, most of the aggravating factors of seriousness did not apply to him. Effectively, the criticism is that the judge applied the same factors in his case as he did when sentencing Sharif and Batul, who had been convicted of murder. This contention ignores the obvious, that Malik was convicted of allowing the death of Sara as well as her serious injuries. How they were inflicted, as represented in the factors of seriousness, were properly taken into account in his sentence, because he allowed them to happen during the time he lived in close proximity to Sara on a day-to-day basis. The fifth ground is that the judge failed to draw a distinction between having allowed the death of Sara rather than having caused it. It is suggested that the sentence should have been discounted to reflect this, and that in failing to do so, the sentence was excessive. The offence of causing or allowing the death of a child, contrary to Section 5, does make no distinction between those who allow or cause the death. Similarly, no distinction is drawn within the relevant guideline. As this court stated in Lennon at paragraph 19, the facts and circumstances of individual cases, of course, differ, but the guideline does not assume or presuppose that an offence of permitting the death will always and necessarily be less than an offence of causing the death. It all turns on the facts of the specific case. Here, the judge was, as we have indicated, entitled to place the applicant's offending within Category 1A of the guideline. His sentencing exercise was faithful to the guideline and to his findings, a fact giving rise to the multiple and serious aggravating factors which we have identified. Contrary to the applicant's contentions, the judge did properly sentence Malik on the basis of the facts, namely that he allowed as opposed to caused Sara's death. The allowing here was extreme. It took place, amongst other things, over a period of months. The final ground of appeal falls away in the light of our conclusions on the applications of Sharif in Batul and Batul. In all the circumstances, we are not persuaded that any of the grounds of appeal against sentence in the case of Malik are arguable. The custodial term of 16 years imposed upon him was within the relevant sentencing range and fully justified on the facts. We refuse his application for leave to appeal against sentence. Conclusion. For these reasons, we grant leave to the Solicitor General to refer the sentence on Sharif to this court, but we dismiss the reference. We refuse leave to Sharif, Batul and Malik to appeal against their sentences. Mr. Ivers, Ms. Carberry, Mr. Meehan, Mr. Little, any corrections of substance or technicality?
Not as far as I'm concerned, my lady.
No, my lady. You've heard it all for the first time. Then it leaves us only to thank everybody for their written and oral submissions in this very difficult and tragic case. We have reached clear conclusions, but that has only been because we have had the benefit of your written submissions. Thank you very much for their clear presentation today in court. Thank you to everybody for attending. Do we need to deal with any documentary issues in terms of access?
No, my lady.
That has all been resolved.
We've distributed our grounds.
And are there any representations from anybody else? No. Anything else? Anything else? No. Thank you to the court.